Well, with those kinds of records, are you going to be able to prove that the dog is unreliable? You know, probably not, because the way I read what probable cause means, it doesn't require 98% reliability. In fact, probable cause doesn't even require more than 50% probability in the Fourth Amendment context. So we may not carry the day that way, but a false statement, a known false statement in a court document makes everybody nervous and unhappy except you. They were dogging your client. Now they're in the doghouse. The prosecutor vaguely remembers some rules of professional responsibility that required him to have candor to the tribunal. To the conscientious judge who hears that there has been a knowing false statement or statement made in reckless disregard of the truth to any judge, now he's on the prosecutor's case, and we're going to argue to the judge, Judge, look, if you find that the handler has lied about the reliability quotient of the dog in the affidavit for search warrant, or for that matter, in his testimony to this court, you have the right to apply the doctrine of falsus in uno, falsus in omnibus, and not give credit to anything the handler said during his testimony or in his affidavit. Look, Judge, you don't even have, based upon the handler's lie about the reliability of the dog and counting it this way in the 11 locker situation, you can deduce that you don't even have to buy the handler's statement that there was a traffic violation for which he stopped Mr. Kane in the first place. You can look at this Frank situation a couple different ways. It was a false statement to say that Winker the Wonder Dog was 98% reliable when you calculate it the way they've done it here with the lockers and the file drawers. Or you can argue that it was a Frank's material omission to omit from the affidavit for search warrant that the way the dog's reliability is determined is by such new math as counting 11 strikeouts as just one strikeout. So really all of that's kind of the good news. The bad news is this. The privacy that you formerly enjoyed in your papers and effects has gone to the dogs. Now the dog actually may enjoy more privacy in its training records and on-the-job performance records and pedigree than you get in your papers. Because you find, particularly in jurisdictions like the 10th Circuit, a lot of judges very begrudging to give us any of the kinds of records like I'm talking about or that we need. You find cases really at both extremes. In the 10th Circuit, you find very stingy judges about giving you doggy records. In the 9th Circuit, on the other hand, you'll find courts holding that discovery of the dog records is mandatory. It's like anything else we're trying to do. We've got to be as creative and as thorough as possible. When we file motions for discovery of these kinds of records, or when we defend subpoenas for these kinds of records, I think bottom line, we want to point out some of the things that we've discovered, even from other cases. For instance, let's show the judge in our motion the quotations from manuals of the certifying entity like Global's that emphasize that the dog training after graduation has to be kept up, as does the record keeping. Otherwise, nobody can say that the dog continues to be reliable. Let's use some quotes from the DEA K-9 interdiction manual as to some of the issues we've talked about. Let's put in our motion for discovery or justification for subpoena false hits that we've heard about from our colleagues in NORML or NACDL or the Bar Association by these same dogs. And let's point out when we've heard or it's been documented that the dog seems to have suffered some deforming injury or be acting rather curiously. When we're trying to get these records, that reminds me to issue kind of a warning that I think is probably commensurate with the business acumen all of us have shown in choosing to become criminal defense attorneys in the first place. Under no circumstances should criminal defense attorneys try to do math in the court. I mean, picture what's going to happen. You've got your righteous motion to suppress set for a hearing. You've got the dog handler subpoenaed. You've got the doggy records subpoenaed. The judge has a tee-off time later that afternoon, and a motion to suppress can be a mess. They're going to give you all these records while the prosecutor's putting on the first witness to bear the prosecutor's burden of proof. You're going to have to try to learn this new math while you're looking through these records and you're seeing that 11 lockers count as only one false alert, and you won't get anywhere.